A persistent misconception surrounds Indian data privacy, the assumption that compliance is a problem reserved exclusively for enterprise-scale domestic corporations. The Digital Personal Data Protection Act of 2023 sweeps across the entire commercial landscape. The law's territorial reach spans far beyond national borders, and its specific enforcement criteria are completely detached from a company's employee headcount or annual revenue. Scale does not dictate liability. If you are a high-growth SaaS startup operating out of Bengaluru, or an e-commerce platform hosted in a different hemisphere entirely, your operations fall directly into this legislative net if they intersect with Indian users. To determine exact compliance obligations, we need to map your operations against an applicability decision tree. We will evaluate 3 distinct nodes: your territorial scope, your fiduciary classification, and the Act's statutory exemptions. Assuming immunity based on corporate scale or domicile is an expensive error. Under the Act, the cost of misclassification is measured in direct penalties and the immediate requirement to overhaul unmapped data architectures. The first node in our decision tree analyzes territorial scope, established under Section 3 of the DPDP Act. This section divides applicability into 2 distinct classes of data processing. This diagram illustrates both categories. First, digital personal data collected and processed entirely within India's borders. Second, data processed outside India. If your external processing involves offering goods or services to users inside India, that connection lights up, triggering extraterritorial reach. The statutory language here is critical. The law specifies data principals located in India. It relies entirely on the individual's physical or digital presence at the exact moment of the transaction. It is not dependent on Indian citizenship. This comparative table shows DPDP Section 3, alongside Europe's GDPR Article 3. Both frameworks utilize shared legal language, designed to capture entities targeting local users. This targeting clause captures foreign SaaS platforms, analyzing Indian market data, and international e-commerce sites shipping to Mumbai. A physical office in India is irrelevant to the legal obligation. Under the DPDP Act, data jurisdiction travels with the user's location. The physical location of your corporate headquarters is superseded by the digital footprint of your customer. Once territorial scope is confirmed, the decision tree moves to Node 2, determining who holds the actual legal burden for the data flow. This hierarchy diagram illustrates the data fiduciary. This central node is the brain, the entity determining the purpose and means of processing. By contrast, processors strictly execute instructions. While holding security obligations, their compliance load is lighter because they don't control the overarching purpose. The fiduciary classification applies to a vast range of entities: private sole proprietors, massive nonprofit organizations, and foreign companies actively targeting Indian users all wear this exact label if they control the data's destination. For startup founders building new platforms, this distinction is immediate. If your engineering team decides why user data is collected and how it is utilized, your company holds the primary fiduciary liability. Outsourcing your server infrastructure to a third-party cloud provider does not transfer this burden. The entity deciding the data's purpose remains the data fiduciary. The final filtration node on our decision tree evaluates Section 17. These are the explicit statutory carve-outs where standard obligations are lifted. This filter outlines the 5 Section 17 exemptions. The first 2 illuminate green for straightforward exclusions: purely personal domestic use, and deliberately publicly available data. The third and fourth cover state governments and research. Notice the padlock on research. This exemption is void without documented data safeguards. The fifth statutory category introduces the power to exempt certain startups and small-scale entities. This creates a severe compliance trap. Founders often believe small-scale grants automatic immunity. It does not. Relief is contingent on forthcoming MIT rule notifications. Until those rules are published, the gate remains blocked. Until the government publishes explicit, class-specific notifications, you cannot assume a small business exemption. Full DPDP compliance remains the absolute default legal state for every commercial entity. Let's run a high-speed stress test, pushing real-world business models through the logic of this decision tree to prove its operational utility. Scenario 1.
A Chennai e-commerce company acts as a fiduciary with no exemptions. Indicator turns red. Scenario 2. A U.S. analytics platform hits the extraterritorial path. Red warning. Scenario 3. University research hits the Section 17 filter, verifies safeguards, and passes. Indicator turns green. Moving rapidly through scenarios 4 and 5, a freelancer maintaining a personal contact list passes clearly into the domestic use exemption. Meanwhile, a government vaccination portal finds itself only partially exempt, still bound by strict security standards. DPDP applicability is not binary. It is determined by the intersection of entity classification, geographic processing boundaries, and the specific purpose of the data collection. We can now transition this legal theory into immediate operational imperatives. Using the decision tree's logic, here is your implementation roadmap. This checklist starts with data mapping. You must locate all personal data flowing through your systems that originates from data principals, physically or digitally located in India. Step 2. Formal entity classification. Document whether you operate as a data fiduciary, a data processor, or meet the higher threshold of a significant data fiduciary based on your data volumes. Step 3 mandates an extraterritorial audit for foreign entities. Identify exactly where your India-facing operations trigger the Act, and begin mapping these specific DPDP obligations against your existing GDPR posture. Finally, complete steps 4 and 5. Assess your exemption status, ensuring you have the legal basis documented, and assign a dedicated internal owner to continuously monitor METI for rule notifications. Executing this applicability analysis is the non-negotiable first step. Attempting to build data governance structures before completing this checklist is flying blind. To accurately map your operations against these complex legal mechanics, you need an expert partner. At Second Quadrant Consulting Solutions, we help organizations across sectors conduct DPDP applicability assessments, ensuring you build a data governance framework aligned with Indian law. Check the description below for a link to a structured applicability assessment resource to start mapping your organization's specific requirements today. Subscribe to this channel for continuous, technically accurate intelligence on Indian data protection law. In the era of the DPDP Act, proactive legal assessment is your only reliable shield against financial penalties. Identify your obligations and build your compliance framework accordingly.